Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
All right, we're back on the record and providing live stream access as well as in the courtroom, continuing the trial of People v. Middleton 25-7050 FH. Bailiff did report to me that that juror that had the family issue did resolve that over lunch and was okay to proceed. Are we ready for the jury?
Yes.
Yes.
Thank you. Sorry. No.
I'm not getting some stuff.
Yeah.
Better than I have room.
She's weighing it.
Welcome back. We're always glad to see the same number return as we sent out into the world. So appreciate that very much. Mr. Juliet, your next witness.
People call Sergeant Michael Pecco.
Sergeant Hecko, if you want to come on to the witness stand, please, and put your right hand forward. You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so be done.
I do.
You can be seated.
State your full name and spell your last name for the record.
Yep, Sergeant Michael Hecko, H-E-C-K-O,
Where do you work?
the Sheboygan County Sheriff's Office.
How long have you worked there?
Just over 12 years.
What's your position?
Road Patrol Sergeant,
How long have you had that position?
3.5 years.
Were you working on May 6th of 2024?
I was, yes.
Accurately recall your shift that day.
It was a year and a half ago, but I remember the case I'm subpoenaed here for.
Okay. You recall being dispatched to a complaint in Wolverine, Michigan that morning.
I do, yes.
Without getting into specifics, what was the reason for the dispatch?
Initially, it was a breaking and entering of a vehicle.
Okay. And did you respond?
I did. I was with my partner, Deputy Kolotsky. He was driving. I was in the passenger seat.
Okay. And so what did you do when you got the dispatch?
We got the dispatch. We started heading towards Wolverine. We were in Sheboygan at the time. When information came out that a vehicle was stolen from the property, we requested to be on the lookout. We put out to our tri-county area through our dispatch to Sheboygan, Charlevoix, and Emmett County. We also requested that we pass along to Gaylord Area Regional Dispatch and requested that a state police car come from Gaylord to head north towards Wolverine to attempt to locate the vehicle.
Okay, so did you ever locate the vehicle?
We did not, no.
Do you recall what kind of vehicle that was?
A blue Ford F-150.
Okay. So approximately between the time of the dispatch and, well, what did you do after you didn't find the vehicle?
So we went down 75 and got to Wolverine. We went south Wolverine on South Straits Highway until we met with the state police car in Otsego County, just a little ways. We returned to the scene then, parked at the Awaken Credit Union next door. My partner made contact with the reporting parties, and I started photographing the scene.
Okay. And what, describe the scene?
So there's a bank that's on the corner of Cedar Street and South Straits Highway. The house is on Cedar Street, just to the west of the credit union.
Okay. Okay, so you started processing the scene. Where did you start?
Started taking photographs of the vehicle that was at the credit union.
Okay. Can I approach?
Yes.
So I'm showing you people's proposed exhibits 2 and 3. Can you take a look at them real quick?
Yes.
What are they?
Photographs of the vehicle that was at the Awaken Credit Union that morning.
Okay. And did you take those pictures?
I did, yes.
Are those pictures a fair and accurate representation of the vehicle on that morning?
Yes.
All right, with permission of people's 2 and 3.
Any objection?
No position.
2 and 3 are admitted?
Permission to publish.
Yes.
Well, before I publish, Sergeant, can you just tell the jury what's going on in 2 and 3?
Okay. And number 2, it's a picture kind of look at the back of the vehicle. The brick building in front of the vehicle is the Awaken Credit Union. And the white house that's behind the vehicle with the light on, that's the reporting party's house. Um,
Go ahead.
Three is from the front corner of the vehicle. Looking back at it, you can see our vehicle and the Tuscarora Township vehicle in the background. While we were responding, as we were checking the area for it, I requested that Tuscarora Township go to the scene to hold that down while we were checking for the stolen vehicle. In this vehicle, you can see some unique dents in the vehicle.
So what did you start fingerprinting it, or what were you doing?
No, so it didn't start fingerprinting that vehicle at that time. I was photographing it. We didn't go into the vehicle. I was able to see some mail on the floorboard of the vehicle while I was photographing it.
Okay, and Your Honor, if I can approach with
Yes.
people's 4 and 5. Yeah, just take a look at these photos here.
Okay.
What are they?
These are photographs I took looking in the front passenger window of the vehicle in exhibits 2 and 3.
Is it a fair and accurate depiction of your vantage point on the night in question? You took pictures,
Yes.
and you did take those pictures.
Yes.
Your Honor, permission of people's 4 and 5.
Any objection? No. 4 and 5 are admitted.
Okay. So, Sergeant, looking at these pictures, what can you tell the jury about it?
So on the floorboard in this picture, you can see the corner of it in exhibit 4. In exhibit 5, you can see a better view of the mail that was on the floorboards that I referenced.
Okay. Were you able to see the lettering on the mail?
I was.
Okay. What did it say?
Harold Middleton with the Sault Ste. Marie address.
Okay. Permission to publish.
Yes.
So what did you do after you saw that mail in there?
The mail on the floorboard being from the Sioux was one of the reasons I requested that the be on the lookout be extended to Chippewa County Dispatch, which they cover Mackinac County and Chippewa County in the Upper Peninsula. I also requested that our dispatch get in touch with the Bridge Authority and make them aware of the stolen vehicle from Wolverine in case it was coming that way, and requested to see if they could locate the vehicle that we had at the Awaken Credit Union coming across the bridge earlier that morning.
Okay. Did the Mackinac Bridge Authority ever provide you with any possible surveillance footage?
They did, yes.
Okay. Do you recall receiving it?
I do, yes.
What did you do with this footage when you received it?
So the footage was emailed to me, Deputy Kolotsky and Deputy Dutchkuski, who also assisted us with this investigation. And then it was saved onto the server and turned over to the prosecutor's office.
Okay. Approaching.
Yes.
Showing you people's proposed exhibit 6. Do you know what this is?
This is the flash drive that contains the surveillance footage from the Mackinac Bridge Authority.
Okay. And is it the same footage that was provided to you by the Bridge Authority?
It is, yes.
Without any alterations or omissions or anything like that?
Correct, yes.
If you did, excuse me, if you did it before today's hearing.
I have, yes.
Thank you. So when you watched the video, what did you make any observations?
Yeah, I noted a vehicle similar to the one that was found at the bank was on that video with dents in the vehicle that matched what we saw with the vehicle on scene.
Okay. What time do you remember what time you saw the car going through the tolls?
I believe the timestamp on the video is 3:03 a.m.
Okay. Now, when you were still there that night, is there anything else relating to the investigation that you did?
On scene that night in particular?
Yes.
I looked at the other vehicle that was left at the residence for possible latent prints on the vehicle left by the people that had stolen the other vehicle. Unfortunately, there was dew, it was like a frozen dew that morning. So I could observe some latent prints on there, but I was unable to lift those prints.
Okay. Now, you said the silver vehicle was at a bank?
Credit union, correct? Yes.
Okay. And did you request any surveillance footage from the bank to see if you could capture anything?
So they were closed at that time in the morning. I worked night shift. I requested deputy judge custody with our day shift and get with the bank to get surveillance footage from that morning.
At some point, well, what ended up happening with that silver vehicle?
We had it impounded. We had it picked up from the scene by Midwest Towing, and Deputy Klotsky and I followed it to our pole barn at the sheriff's office and had it secured in a locked pole barn.
Okay. Did anything happen to it, from when it was at the bank to when it was towed to the sheriff's department?
No, that's why we followed it, to maintain chain of custody of it.
Okay. Thank you. I have no other questions.
Suzanne? I just thank you. Happy Sergeant.
Good afternoon.
So I just want to be clear about what you did and didn't do on scene, okay? So you arrived, I think something like 4:37 a.m. Does that sound right?
That sounds correct.
To the Harbor residence?
I think we parked at the credit union.
Okay, so I'm sorry, I'm trying to cut you off. So you parked at the credit union, and then you and Deputy Kolaski walked over to the Harbor residence. Does that sound right?
Correct.
Now it also sounds like you both may have left at a certain point when Tuscarora Township arrived on scene. Is that also correct?
That's not correct.
Okay.
Tuscarora, they're Indian River, so they're closer to Wolverine than we were from Sheboygan. So we had them respond to the bank. That way they were with the vehicle that was left there. Then we went down 75 and we were searching for the stolen vehicle while they maintained at the bank there. When we came back, Tuscarora stayed for a little bit and then they left, but we did not leave.
Okay, so you and Deputy Kolaski weren't actually first on scene, then it was TTPD that arrived on scene first. Is that fair?
That's correct. Yes.
Okay. And you guys weren't just lollygagging, you were out looking for the car, right?
Correct.
Okay. And your main responsibilities here then were to take photos of the silver car in the bank parking lot. Is that right?
I guess main responsibility is that this was Deputy Kolaski's case. He was the primary officer. He was driving. I was the passenger. I'm just assisting him with his investigation. And by taking photographs, that was one of the ways I assisted with it.
You also tried to lift some latent prints from the car that was still at the Harmer residence, right?
Well, I didn't attempt to. I photographed them, but because of the dew, I was not able to.
And to be clear, I guess for the juries, for the juror, when you try to take prints, what's that process like?
Fingerprint powder dusting, which would not work well with water.
So the powder itself doesn't stick to the dew. Is that what you're saying?
I believe it would have stuck to the dew, and trying to lift the print out of there would not have been successful.
So you looked at that and then looked at the conditions and said, we're not even going to try because it's not going to work.
Correct. Yes.
Now, there were some fingerprints that were taken. Did you take those or did Deputy Kolaski take those?
I took those.
Okay, so from the silver Ford vehicle that's in the credit union parking lot, there were prints that were lifted from that car, right?
Correct. After it was in our pole barn and a search warrant was authorized to search that vehicle, I attempted to lift latent prints from it.
And you were successful to lifting at least 2 prints from it, right?
I lifted 2 prints, correct, yes.
And one of those prints was from the passenger door handle. Does that sound correct? That's correct. And then also from the shift knob that would have to be used if you were driving a car, right?
Correct.
And nothing that you learned of value from that exercise. Does that sound fair?
That's correct.
Now, sounds like you also called in to the Bridge Authority to get the video, right?
I'm sorry, can you repeat that?
Sure, yeah. It sounds like you also called into the Bridge Authority to get that video from the Mackinac Bridge.
So I requested our dispatch check with the Bridge Authority. Then I asked Deputy Judge Gauthier to request surveillance video from the bridge. They emailed it to me and Deputy Judge Gauthier, a couple still photographs. I replied asking for video, and then they supplied a video that appeared to be a cell phone video of the recording. And then Deputy Kolosky requested, the best video coming directly from the computer. And that
The
was sent
actual
to all of
video.
us. Correct.
Instead of a video of a video.
So essentially we all requested.
Okay.
Surveillance.
Got it. No, I think you testified earlier there were some unique dents on that silver car. Were you able to see those dents in the bridge video?
I was, yes.
You also found some mail on the passenger side floorboard of that silver car, right?
That's correct.
To be clear, there wasn't just one envelope that was in the car, right?
So that was what I could see on scene. Deputy Kolosky then searched the car with the search warrant. While I was doing the fingerprints, testing for fingerprints on that vehicle, he did the search. I think he'd be better to testify to what other mail is in the vehicle.
Sure, fair. Okay, so you didn't actually do the search inside the vehicle, just the printing on the outside.
And the inside, the shift knob.
Oh,
Correct.
Thank you.
Mr. McGill, would you be so kind as to retrieve the exhibits from the jury and hand them to me? Yes, thank you. All right, any redirect, Mr. Juliet?
No, Your Honor.
Do any members of the jury have questions for this witness? Seeing none, Sergeant, you can step down. Thank you.
Thank you.
Mr. Juliet?
People call Michael Dooley.
Mr. Booby, if you want to come out to the witness stand here, and as you arrive, please raise your right hand for us, sir. Swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth. So,
I do.
okay, you can see it.
You state your full name and spell your last name for the record, please.
Mike Buby, B-U-B-Y,
Okay. And where do you work?
back in the bridge.
Okay. What is your current position there?
I'm the operations manager. I'm in my 26th year.
Okay. And what does that entail?
I oversee the tolls at the bridge. I'm also on the administration team.
Okay. So when you say you oversee the tolls, what does that mean?
We have approximately 30 toll collectors that I oversee on their day-to-day operations of processing traffic.
Okay. And now, does that involve some sort of surveillance system within the toll booths?
We do have cameras inside and outside the toll booths. We also have the whole plaza area is covered by
Okay.
security.
And is it your responsibility for maintaining this sort of surveillance? Are you in charge of that?
Yes.
Okay. Do you have any sort of standard procedures that you use for ensuring that cameras are working accurately? And if so, can you describe it?
Well, they're staffed 16 hours a day, and I use that system every day, 40 hours a week. I use them for a variety of reasons.
What are a few reasons?
Auditing is one of the big ones.
Okay.
Because the intent of them is in the booth, because we handle such large volumes of cash, just to monitor our employees and make sure that verify the classifications and the cash, the credit or debit transactions.
Okay. Basically to make sure nobody's stealing. Fair.
That's fair.
Okay. Now, can you recall back to around May 6th of 2024?
I do recall the date, yes.
Okay. And were the cameras functioning properly that day?
Yes, they were.
Okay. How are the recordings generally stored? Are they on a server or?
Well, they are on a server. The system retains them for 30 days unless I download them
Okay.
and put them in what we call the vault.
Okay. Now, did you on or around May 6th receive a request from law enforcement for possible surveillance footage?
Yes.
Okay. And did you personally look for the footage?
Yes.
Okay. What did you do? Did somebody come and check with you to see the footage, or how did that work?
Typically, when they request it, I'll review the dates and times of the request. And I will save that in our software.
Okay.
And that stays there until they come and ask for it.
Okay. Did they come and get it?
They did. I typically downloads on a thumb drive that is provided by law enforcement.
Okay. Can I approach now?
Yes.
Mr. Buby, I'm showing you people's proposed exhibit 6. Do you know what this is?
Yeah, it's a thumb drive or a flash drive, and that would be used to download video.
Okay. Now, have you viewed this, the contents of this flash drive before today's trial?
Yes, I have.
And without getting into the specific contents, what is it?
It verifies of a vehicle and an individual passing through the tolls.
Okay, and is that the video that law enforcement requested and retrieved?
Yes.
Okay. And reviewing that footage before today's hearing, is it a fair and accurate reporting of what you gave law enforcement?
Yes, it is.
And did you initial this after you reviewed it?
Yes, I did.
Your Honor, I would move for admission of People's Exhibit 6.
Any objection?
No, Judge.
Exhibit 6 is admitted.
Thank you.
Any cross-exam?
Good afternoon, Mr. Buby.
Good afternoon.
Thanks for being here, and you sound like a busy guy. Couple of questions. You mentioned that it's part of your duties to ensure that the cameras are functioning properly. Is there a situation where you know that they're functioning properly in real time, or is it usually you find out after they're not working correctly, that they're not working correctly?
I guess it'd be a little bit of both. I mean, it's possible that a software update or something of that nature could take place on a weekend, and I wouldn't be aware of it until Monday.
So when you get a request from law enforcement, I imagine that happens fairly frequently. And how many times a year do you do that? 50 times a year, 100 times a year?
25 times a year.
Okay, so
Average.
it's frequent.
Fairly frequent, yeah.
And when you get that footage, you mentioned that that law enforcement brings you the device to download that
Yeah,
footage
I
onto.
typically request that they bring their thumb drive in.
Okay. And so it's safe to say that they bring the equipment to you, you put it on there, and you don't know what else is on that thumb drive.
I do not.
When you download the video onto the thumb drive, do you just hand it back off?
Yes, we're in the room together.
And you just hand it back off?
Yes.
I don't have anything else. Thank you.
Okay,
Thank you, Direct.
No, thank you.
Any questions for this witness? Okay, seeing none, may Mr. Buby be excused from the subpoena?
Yes,
Okay,
please.
sir, thank you. You can sit down. You're excused from subpoena.
thank you.
Hey, Mr. Juliet?
People call Deputy Dave Tiggio.
Deputy Wichowski, if you want to come on the witness stand and raise your right hand for me, please. You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth shall be done.
I do.
Okay, you can be seated.
Can you state your full name and spell your last name for the record, please?
David Ditchkowski, last DUCZKOWSK.
Okay, where do you work?
the Sheboygan County Sheriff's Office.
And what is your position there?
I'm a road patrol deputy.
How long have you been doing that?
I've been on the road for 3 years, worked here for 5 years.
Okay. Were you working on May 6th of 2024?
I was.
Okay, and do you work the day shift or night shift?
I work day shift.
Okay. Were you involved in the investigation of a stolen automobile in Wolverine?
Yes, I was.
How so?
I was requested by Sergeant Hecko to obtain security footage from the Awaken Credit Union in Wolverine.
Okay, and that morning or that day, did you go retrieve it?
I did. I went down there.
Okay, so what happened when you got to the bank?
I got to the bank and they had me review the security footage, and then they said they needed a search warrant to put it onto a thumb drive. So I went and got a search warrant and came back and they gave me the thumb drive,
Okay,
the security footage.
so that was after you got the search warrant?
Correct.
And what did you do with it? Did you look at it?
I did.
Okay. Deputy, I'm showing you People's proposed exhibit 7. Do you know what's on this flash drive?
I do.
Okay, what is it? Without
That's-
getting into the contents.
The security footage from the credit union.
Okay, and have you viewed it before today's hearing?
I have.
And is it a fair and accurate representation of the security footage that they gave you?
Yeah.
On the day you requested it?
Yes, it is.
Your Honor, I would move for permission of People 7.
Any objection?
I just have 1 minute. No objection, thank you.
7's admitted.
Okay. So Deputy, how long is the video footage?
It's approximately an hour.
Okay. And, you know, without getting into the entire hour-long video, did you observe anything that might be suggestive of a stolen automobile that night?
Judge, I'm gonna object that the exhibit speaks for itself and the jury hasn't been able to watch it yet.
I'm gonna overrule that. I think he can testify about what he observed on it.
So I watched video, observed 2 individuals come from the side of the building. They walk across the parking lot. They go over towards the house where the stolen vehicle was from. They go into the garage, kind of back and forth. And then you see the blue F-150 that was stolen drive in front of the camera a little while later. This was over the hour. It's back and forth and stuff.
Okay, thank you. I have no other questions.
Any cross-exam?
Just briefly, Deputy, so did you arrive on scene with Deputy Kolatsky and the sergeant?
I did not.
Okay, so did you come before or after them?
I was after them.
Was Tuscarora Township already there when you arrived?
They had already left.
So they left by the time that you had arrived on scene?
Correct.
Okay. Was the silver car still in the bank parking lot when you arrived?
It was not.
Okay, so it had already been towed.
Correct.
Did you witness that tow?
I did not.
Because you weren't there yet.
Correct.
Now, other than what you talked about, did you have any other sort of involvement with gathering evidence, other surveillance footage, DNA prints, anything like that?
Nothing with the only other thing would have been some contact with the Mackinac Bridge Authority for some footage from there too.
Did you have any involvement with Genesee County Sheriff's Office at some point?
Don't recall having any with them. I don't.
Did your involvement with this case end after the 6th?
Yes.
No further questions. Thank you.
Any redirect?
No.
Any questions from the jury for this witness? Okay, seeing none, Deputy, thank you. You can step down.
Thank you, Your Honor.
Mr. Juliet?
People call Deputy Kolatsky.
Kolatsky? Please write in for me. You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do. Deputy, can you state your full name and spell your last name for the record?
Deputy Darren Klotsky, Kolatski.
And where do you work?
Boyne County Sheriff's Office.
How long have you worked there?
Almost 4 years.
And what is your current position?
Road patrol deputy.
How long have you been doing that?
I've been full-time on the road for almost 2 years now.
You're working on May 6th, 2024.
I was.
Can you accurately recall your shift that day?
I do.
Did you have some contact with Morgan Harmon that day?
Yes.
Just briefly describe what the reason for the contact was.
I ended up having contact with her after we responded to, started as a breaking and entering of a vehicle, turned into theft of a vehicle. After attempting to locate the vehicle, we made it to the scene. And once we were on scene is when I made contact with her.
Okay. So without getting into what she said, how did you begin your investigation?
Originally, we arrived on scene and we met with Tuscarora Township, who was there before us. We observed the silver Ford 500 parked at the bank that was reported to be there. And then I made my way up to the house and spoke with Ms. Harmer about what she observed.
Okay. Now, at some point, did you start an investigation into that silver Ford 500 being at the bank?
Yes.
So what did you do?
At that time, Ms. Harmer reported that the people were, that she observed going back and forth to the vehicle. We were looking from the outside of the vehicle and we observed a piece of mail on the passenger side floorboard that had a name on it.
What was that name?
Harold Middleton.
Did it have an address?
It did.
And where was that?
It was out of Sault Ste. Marie, Michigan.
Is it fair to say that at that point, Mr. Middleton became a possible suspect?
Correct.
Okay, so what, if anything, what further investigation did you take into the vehicle?
At that point, we didn't do an inventory of the vehicle or go inside of the vehicle. We impounded and seized the vehicle, the entire vehicle, to have it transported back to the sheriff's office to apply for a search warrant.
Okay. Did you apply for a search warrant?
I did.
Was it granted?
It was.
Okay. So at some point, then you searched the vehicle pursuant to that warrant?
Correct.
Was that at the sheriff's department pole barn out there?
Yes, it was.
Was it just you that was sort of taking pictures of the inside of the vehicle?
I took all the photos during the search warrant except for the fingerprint photos. Those were taken by Sergeant Hecko.
Okay. Like approach, Your Honor.
Yes.
Just want to approach with people's proposed exhibit 8. What is it?
That is a picture of the silver Ford 500 that was located at the Awaken Federal Credit Union and towed back to the Sheboygan County Sheriff's Office to be stored in the pole barn.
Did you take that picture?
I did.
Is that a fair and accurate depiction of the vehicle on that night stowed back to the sheriff's department?
It is.
You are ready for admission to today.
Objection?
No. Publish.
Yes.
Can you just briefly tell the jury what's going on there?
Yes. Like I said, this is a picture of the vehicle in our pole barn. Before I started the search warrant, I photographed the outside of the vehicle. I was able to observe some unique denting in the front driver's side fender.
Permission to free approach.
Yes.
So I want to show you people's proposed exhibits 9 through 20. Just take a minute, go through those real quick. Start off with proposed number 9. What is that?
It is a piece of mail that was located in the trunk of the vehicle during the search warrant, with Harold Middleton's name on it.
Okay. And did you take that picture?
I did.
Is it a fair and accurate depiction of the mail that was in the trunk on that date in question?
Yes.
All right, move for admission of people's 9.
Any objection?
No.
9 is submitted.
Permission to publish.
Yes.
So 10, what is it?
A piece of mail with Harold Middleton's name on it. This was located on the passenger side front floorboard. This is the piece of mail that we were able to observe through the window on scene.
And you took that picture?
I did.
And it was a fair and accurate depiction of the picture the night you took it?
Yes.
Move for admission of people's 10.
Any objection?
No.
10 submitted, may be published.
What's exhibit 11?
This is it's a DHS document with Harold Middleton's name on it.
You took the picture?
Yes.
And fair and accurate depiction of the picture that night, or the document that night?
Correct. With some redacted spots on it.
Move for admission of people's 11.
Any objection?
No.
11 is submitted, may be published.
Okay. And so where did you find this picture at?
This picture was a piece of mail or a document that was located inside the vehicle during the search warrant.
Well, what is it?
Another piece of mail that was located during the search warrant of the vehicle with Harold S. Middleton III, addressed to Harold S. Middleton III.
Okay. Fair and accurate depiction of the envelope when you on that night.
Yes.
Move for admission of people's 12.
Any objection?
No.
12 submitted, may be published.
13. Hold on here.
This is 4 separate pieces of mail that were located inside the vehicle during the search warrant, addressed to 4 different people, one of them being Harold Middleton.
Fair and accurate representation of the envelopes when you were taking the pictures.
Yes.
And I want to move for admission of people's 13.
Any objection?
No.
13 submitted, may be published.
And you said one of these was Mr. Middleton's envelope.
Yes.
What is people's 14?
This is a picture of a wallet that I located inside the vehicle during the search warrant. It was located between the driver's seat and the center console, kind of towards the back seat a little bit.
Okay. Fair and accurate depiction of the wallet when you found it.
Yes.
All right, move for admission of people's 14.
Any objection?
No.
14 submitted, may be published.
Without getting into the contents, what is people's proposed 15?
It is a picture of a wallet, the same wallet, opened up, that I located during the search warrant of the vehicle.
Fair and accurate depiction of what the wallet looked like and opened up that night.
Yes.
All right. Permission equals 15.
Any objection? No. 15 submitted, may be published.
Equals 16 without the meaning of the contents. What is it?
It's a picture of an identification card that was located inside of the wallet that I located during the search warrant of the vehicle.
Fair and accurate depiction of the ID card when you took the photograph.
Yes.
Permission equals 16.
Any objection? No. 16 submitted, may be published.
Equals 17. What is it?
It's another picture of the inside of the wallet opened up with the Michigan identification card pulled out to be more visible. The same wallet that was located during the search warrant of the vehicle. I mean,
Good representation of what opened up wallet in the picture.
yes.
Permission equals 17.
Any objection? No. 17 submitted, may be published.
Equals 18. What is it?
This is a picture of all of the items inside of the wallet, taken out and laid out on the hood of the vehicle during the search warrant. I laid them all out to photograph them.
Fair and accurate depiction of the ID cards when you laid them out.
Yes.
I would move for admission of equals 18.
Any objection? No. 18 submitted, may be published.
Equals 19. Was it?
It's a picture of one's a debit card. I think they're both debit cards from inside the wallet that was found during the search warrant of the vehicle by me.
Fair and accurate representation of the debit cards when you found them.
Yes.
Move for admission equals 19.
Any objection? No. 19 submitted, may be published.
Deputy, whose name is on those debit cards?
Both of them have the name Harold Middleton on them.
Showing you people's exhibit 20. What is that?
This is a debit card that was located inside the vehicle during the search warrant.
Okay. It wasn't located inside the wallet.
I believe this one was located just fell in between the seat near where the wallet was.
Okay. Fair and accurate depiction of the card when you took the picture.
Yes.
Move for admission equals 20.
Any objection? No. 20 submitted, may be published.
Whose name is on that card?
Harold S. Middleton III.
Now, I want to go back to this Mackinac Bridge surveillance video. Have you viewed it before today's hearing?
Yes.
Okay. When do you first recall viewing this footage?
The video footage, we received the first copy of it relatively quick after the incident when we requested it from the Mackinac Bridge.
Okay.
That was, the first copy was a video from like a device of the screen. We reviewed it that night and I ended up requesting the actual copy from the computer for a clearer view.
Okay. And is that what is on People's Exhibit 6?
Yes.
Your Honor, can I approach the bench? Just this is for the file.
Oh, yes, thank you.
Have TV turned on. Deputy, is this the video of the bridge surveillance?
Yes.
Your Honor, this exhibit has been admitted. I'd like to publish to the jury at this point.
How long is this video going to be?
and 12 seconds.
Oh, any objection? No. Okay. Go ahead.
Now, Deputy, when you watched that video, was this after you took photos of the vehicle pursuant to the search warrant?
Yes, I believe it was.
Okay. Now, when comparing those, are there any specific things that you know are similar?
Yes, so
If you need me to turn that back on.
well, as the vehicle pulls up, you'll see the front driver's side fender right there with the dent in it. I observed this same unique dent in the vehicle at the bank or the credit union the night of the incident, as well as when I was photographing the vehicle prior to the search warrant in the sheriff's pole barn.
Your Honor, can I approach?
Yes.
Showing you people's proposed exhibits 21, 22, and 23. What are they?
These are screen grabs from the bridge toll video.
Did you screenshot them yourself?
Yes,
So you like paused it and then took like a snag it or something like that?
correct.
And you did that yourself?
Yes, I took some of the screenshots for I took some, I believe the detective took some, but I believe these were some that I screen grabbed on the department computer.
Okay. And do these photos accurately reflect the original contents of the video?
Yes.
Okay. I would move for admission. It was 21, 22, and 23.
Any objection?
No.
21, 22, and 23 are admitted.
So we'll start with 21 was in there.
Oops. So this is a picture, a screen grab from the lane 9 southbound booth at the Mackinac Bridge. In reviewing the video, I was able to observe a white male wearing a black t-shirt with white lettering on the front, and hand tattoos, hand and wrist tattoos on his left arm.
Yes.
This is another screen grab from the same video depicting basically the same thing. White male with the hand tattoos, the very unique hand tattoos, paying at the toll. Similar with the more visible hand tattoo in this photo of the subject going through the lane 9 southbound toll at about 3:03 a.m.
So you said that based on the mail and the ID cards that you found in the vehicle that Mr. Middleton became a suspect in this investigation?
Correct.
Okay, and did you ever have a chance to meet with him?
I did.
How long after this incident was it?
Approximately a year.
Okay. And the interview was regarding this stolen vehicle complaint.
Correct.
Okay. So what did your interview consist of?
I took photographs of Mr. Middleton's hands and some of the tattoos on his forearms. And I spoke with him about the incident, and explained what I was investigating, and asked if he wanted to, told him I was there to get his side of the story about what had happened on the night in question.
Can I approach?
Yes.
You just proposed 25 or 24 and 25, excuse me. Let's take a minute to those. What are they?
Those are photographs that I took of Harold Middleton's hands when I spoke with him, of the tattoos on his hands.
Okay. And you took these pictures?
I did.
They're a fair and accurate depiction of his hands on the day you took pictures.
Yes.
And I would move for admission of people's 24 and 25.
Any objection?
No.
24 and 25 are admitted?
And permission to publish respectively.
Yes.
So can you tell the jury what's going on at 24?
So it's a picture of the tops of Mr. Middleton's hands. The left hand, I was able to observe tattoos that correlated with the tattoos on the hand, the left hand of the driver going through the Mackinac Bridge toll in the video.
And 25.
25 is an up close picture of the Harold Middleton's left hand. Again, consistent with the tattoos I observed in the Mackinac Bridge toll booth video.
Is Harold Middleton present in the courtroom today?
Yes.
And where is he seated at?
At the defense table,
What color shirt is he wearing?
blue.
Your Honor, can I let the record reflect that Deputy Pulaski has identified the defendant in this case?
So noted.
Now, as part of your investigation, did you also review their surveillance footage from the bank? And it's approximately an hour long.
Correct.
Okay. Your Honor, if I can approach the bench, I do have People's Exhibit 7 here. Sorry, thank you. I want to show you People's proposed exhibits 7A, B, and C. Do you know what's on these flash drives?
Yes.
Okay. Without getting into the contents, what are those?
Those are shortened clips of the hour-long original bank security video.
Okay. And they've been, do they still capture what's contained in the original video?
Yes.
Okay. And you reviewed those before today's hearing?
Correct.
Your Honor, I would move for admission of People's 7A, B, and C, noting that 7's already been admitted.
Any objection?
No.
All right, 7A, 7B, and 7C will also be admitted as excerpts of Exhibit 7 for ease of viewing.
Your Honor, if I can TV again.
Which one are you going to present
7A, 7B, and 7C.
in that order without questions in between?
With questions in between each.
Okay, so let's just put on the record which one we're playing, and then so we're going to do 7A first.
So Deputy, can you note what you observed in that portion of the surveillance video?
Yes, in that portion of the video, I was able to observe two males matching the description from the 911 call coming from the north side of the Awakened Federal Credit Union Bank, coming from the location where the silver Ford 500 was parked and walking up towards the location of where the F-150 was stolen from.
And permission to publish People's 7B.
Yes.
Now, Deputy, if you need to use your pen to highlight what's going on.
Yeah, in the upper left corner, you can see the white building there. And you just seen two subjects walk past the white building. And there's two buildings there. The one on the left is a house, and then the one on the right is a garage. The subjects walk past the house and disappear for a minute. And then watch the garage window. You can see lights come on inside the garage as somebody has entered the garage and is inside of the building. And the light goes off in the garage. And then two subjects exit the garage. One goes back towards the vehicle, and then one heads back down towards the Ford 500 at the credit union. Observe the male that's still in screen to be one of the males that had originally walked up towards the vehicles in the last video, dressed in all black with a white stripe.
Permission to publish People's 7C.
Yes.
Get Deputy, yeah, use your laser pen, that's fine too.
Observe the male in the camo with the white writing on the front of the black shirt and the ball cap walking back from where the vehicle had ended up being stolen from, meets back with the other subject that had walked down towards the Ford 500 in the previous video. observed them make their way back towards the Ford 500, which is just around the corner on the north side of the building where they just disappeared to. At this point, subjects move back up towards where the vehicle ends up being stolen. There's the male in the camo. And then the second male I observed to be wearing all black and only have a small white Adidas logo on his sweatshirt. Like I stated a minute ago, I observed the male in the camo to be wearing a black shirt with large white writing on the front of it. That was consistent with the black t-shirt that the male was wearing in the Mackinac Bridge toll video.
Is it fair to say that's all you observed in this video?
I believe so. I was looking for, I don't know if it's in this video or the full length video. There's, after they walk up to the truck, there's a brief moment you can see the headlights from the truck flash across the grass as the truck is being taken.
Thank you. I have no other questions.
Any cross exam?
Yes. Afternoon, Deputy, how are you doing?
Good.
So you were the lead deputy on scene, is that fair to say?
Correct.
Okay. And as we stated earlier, with Sergeant Hecko, you guys arrive on scene at the credit union somewhere about 4:37 in the morning.
Yes.
And this is after you both had gone out and were trying to find this truck that had been stolen, right?
Correct. We continued south for a little ways before we made our way back north to the credit union.
You come back to the credit union, you then go make contact with Morgan Harmon, correct?
Yes.
And that's obviously the house that's right behind that credit union parking lot that we just saw in the video, right?
Yes, it was the white building in the top left corner.
Now, you take statements from both of the harmers on scene, right?
I spoke with both of them up at the house, yes.
And they give a description to you of the suspects, correct?
Yes.
And in your police report, you put that as both subject as white males, approximately early 20s. Does that sound right?
Correct.
Are you aware that Mr. Middleton's date of birth is like February of 1991?
I was not aware, or I am not aware of his exact birthday now.
That date of birth was contained though as a part of the report that you made in this case, right?
Correct. I just don't recall it off the top of my head.
And that's fine. I'm not expecting you to memorize his birthday, but fair to say that that is accurate in your report.
I would have to look at the report to see the exact birthday I put on the report, but it should be his date of birth.
So let's switch gears just a little bit and we'll talk about the car that's in the credit union parking lot. So that car was, as you were investigating this, right, you run the registration on the vehicle, correct?
Yes.
That registration comes back to an individual, right?
Yes.
That individual is not Harold Middleton, correct?
Correct.
And you're the one that actually lifted the prints off of the car, right? Or was
No,
that
that was
just Gauthier?
Sergeant Hecko.
Okay. You searched the inside of the car while he did the prints.
Correct.
Were you the one that sent the prints in for analysis?
Yes.
And that analysis returned nothing of value, right?
Correct.
You also, during the search of that car in the credit union parking lot, you obviously find a bunch of mail that's in the car, right?
Yeah, the search was at the pole barn though.
Right, but the car that was at the credit union then goes to the pole barn, you
Yes.
search it, you find the mail.
Correct, yes.
And there were multiple pieces of mail in there, right?
That's correct.
I think you have, looks like 4 different items on your report, just involving pieces of mail. Item number 8 was 4 envelopes of mail that were addressed to 4 different people at that address that has been redacted from the file, right?
Correct.
Item number 9 was 2 pieces of mail addressed to 2 people at that same address, right?
Yes.
Item number 11 was 5 pieces of mail addressed to 3 people at that same address, correct?
I believe so. There was a lot of evidence items that were all mail items that had different names on them.
And those pieces of mail, to be clear, like some of it was found in the passenger floorboard, some of it was found in the trunk. It was just kind of all over the car, right?
Yes. Yeah.
Item number 10 was also, there was a single piece of mail there with Harold Middleton's name on it, right? And that was the one that was found in the floorboard.
I believe that was number 10.
You then also find that wallet that we've already talked about, correct?
Correct.
This might be kind of a stupid question, but what's a bridge card?
A bridge card, like a governmental assistance card, referred to as a bridge card or a food stamps card.
So what does that do?
Objection. I don't know what the relevance of this is.
Can we approach?
Yes.
So you then are still involved in this investigation, right?
Correct.
Were you the one that received the report from Genesee County?
I was.
Okay, and I know that Mr. Juliet in his opening statement says that this vehicle was never seen again, but that's not correct, right?
It was never seen by the Harmers again, but
Sure.
it was later recovered by another county downstate.
Okay, and that was in Genesee County?
Yes.
If you can recall back to the bridge video itself, I believe that Sergeant Hecko stated the timestamp on the bridge video was approximately 3:03 a.m. Does that sound correct to you?
I believe so, yeah.
You could also see a clock that's flashing in the corner of that video, right?
I believe there was a timestamp on the video, but I wasn't
Yeah, because there's a timestamp that's up in the upper left of the video, right?
Okay,
And then you see there's a clock right in front of the teller that's flashing the time as well. Do you remember seeing that?
I wasn't looking at that.
Okay. Would it surprise you if those times are different?
I guess not.
I could have just one moment, Judge. Sorry about that. Okay, so when you talked to Genesee County about the truck that was recovered down there, did they report any suspects to you down there?
No,
Okay. Did they try to lift any prints to your knowledge from the truck?
they did not. They stated due to the high volume of stolen vehicles recovered down there, and the fact that it was recovered in an abandoned, it was recovered abandoned in an abandoned lot with heavy damage and missing parts. They elected not to attempt to take anything from it.
Okay, so to your knowledge, they just said no, thank you, and did not do that.
Correct. They,
Okay.
from what I was told, they, due to the high volume of stolen vehicles, they ran the vents and it was stolen and recovered it, and that's about where they left it.
Yeah. Back to the mail that's in the car just a little bit. Right now that we talked about, there were several different names on several different envelopes contained inside of the vehicle. Did you interview any of those other individuals who were named in the car?
No, I attempted to interview one, but was unable to make contact.
Okay. But there were obviously other people that were listed, so you did not talk to any of them. Is that correct?
That's correct.
No further questions.
Any redirect?
Yes, what was, do you recall the name of the person who the vehicle was registered to?
Yes, Emily Pavia.
Okay, and she was out of the Sioux as well?
Correct.
Your Honor, if I can just approach for the exhibits.
Yes.
Just approach the witness and the bench.
Yes.
I'll file these. So I'm showing you exhibit 13. Can you read the names off of the envelopes?
Jania M. Everett, Raquel Ray Everett, Harold S. Middleton III, Alyssa G. Everett Fish.
Thank you. All right.
Can you recross on those points?
Yes, just briefly. So I think Mr. Juliet's trying to get at whose names are in the envelopes. Was there any other male names that were on any of the envelopes?
I would have to review the other envelopes. I believe there might have been one other male's name.
And seems like all of those individuals, at least at some point, resided at the same address in Sault Ste. Marie. Is that correct?
Many of them had the same address in Sault Ste. Marie, yes.
And as far as trying to contact those people, I know you already said you only contacted or attempted to contact one of them. Is that right?
Correct.
Did you just make like one phone call? What did you do to try to contact them?
I made multiple phone calls. And somebody did answer the phone, and when I asked for the subject, they asked who it was, and I told them who I was with the Sheboygan County Sheriff's Office. The phone rustled around. Someone on the other end of the line stated it's the cops. It rustled around some more and disconnected, and I was never able to get them to answer any further phone calls after that.
The truck itself was located June of 24, is that right?
I believe so.
I know it's not your report, but would it help to refresh your recollection if you were to look at the Genesee County Sheriff's Office report?
Yes.
I'm gonna check this beyond the schedule redirect.
Well, it is, I'm gonna allow it, he's just trying to establish when the vehicle was recovered in Genesee County, and I think that's an important fact. Yeah. Yes.
So this is the Genesee County Sheriff's Office report. Please read it.
Okay.
Commissioner Pershing,
Yes.
is your recollection refreshed?
I believe so.
So sounds right to you, this the truck was recovered June 21st of 2024.
Yes.
And did you ever go down to attempt to lift any prints from it?
I did not.
No further questions this time.
All right, since I allowed a little bit more on recross, any questions on that?
No.
Okay, any questions for this witness from members of the jury? You can write it down on the form, correct? Council approach. Okay, what we're gonna do is we've been going a little bit since we got you back from lunch. We're gonna send you back into the jury room for a little 5-minute stretch, and while we talk a little bit, and then we'll bring you back in shortly.
All right.
All right, please be seated. Okay, so we did get a question from a juror. It actually is 3 questions. says, what did the registered owner of the silver car have to say? Did they know Harold? Was the car stolen? Obviously, I think the answers to those questions through this witness would be hearsay. So my approach would be to not ask those questions. Is that correct, Mr. Juliet?
Yes.
And Mr. Nightingale, you would object to those questions being answered through this witness, is that right?
Yes, Your Honor.
Okay, and I suggested to counsel at the bench that maybe this is a good time to give the jury a stretch, and then just for me to sort out, like, I know the jury's gonna have, as I do, all of those questions in my mind, and I note that Ms. Pavia was on the witness list. Are we calling her, or what's, do you know where we're heading on that question or issue, Mr. Juliet?
I am not calling her.
Okay, are you calling?
No.
Okay. Do we know, are those questions going to be answered in this trial or not?
No.
No.
Well, okay. The jury and I will always wonder, I suppose. Okay, we're ready to have the jury back? Or should we, since I just sent them back, do you want to take a 5-minute recess?
Yeah, sure.
Okay, let's resume at 2:30. And you can step down in the meantime. Yes.
One of the jurors on her way back said that she had a question, tried to hand it to me, I didn't take it. She asked if it was too late.
No, we'll wait till she comes back and we'll address it. All right, counsel, ready for the jury?
Yes.
All right, do any other jurors have questions for this witness? Show of hands. Okay, you want to write it down? Counsel, please. Hey, Mr. Juliet, did you have any additional questions for this witness?
I did. So Deputy, when you, back to your interview with, the defendant, you told him you were investigating the crime we're here for today.
Correct.
Did he respond in any way?
Yes, I asked him if he had been in Sheboygan County on the date in question. He stated he hadn't. And I asked him if he had currently owned or had ever owned a 2006 Ford 500. And he stated that his girlfriend did, and he had been in the vehicle before but never driven it.
Okay. Did he say, like, in relation to the time of this incident, any indication of when she was driving it?
No, he just advised me that she owned a vehicle that I questioned him about. And again, I asked him if he'd ever driven it, and he stated he hadn't, but he'd been in it.
Thank you.
Any repress on those points?
Yeah, just. So, Deputy, this incident date is May 6th of 24, right?
The original?
Yes.
Correct.
And you interviewed Mr. Middleton, April of 25. Does that sound correct?
Yes.
So almost a full year later that you're talking to him about this.
Correct.
No further questions.
All right, I'm gonna step down, Deputy. Thank you. Mr. Juliet?
People rest.
Okay, we're gonna send you back into the jury room for another very brief intermission, and we'll bring you out in a couple minutes.
All right.
All right, please be seated. All right. After the questions from the jurors, the juror that I didn't ask that were hearsay, I did consult with counsel and chambers, and Mr. Juliet had requested permission to ask those additional questions about the statements that the defendant made, to answer some of the lingering questions, perhaps about the ownership or lawful possession of that vehicle. And I indicated that I would allow some leeway to reopen exams, since I had allowed the defense some leeway on recross. Mr. Nightingale, did you have any objection you wanted to place on the record to that process?
No, not this time, Your Honor.
Okay. And then we also did receive another question from a juror when we came back out, and it reads as follows. If the defendant is a member of the Sault Ste. Marie tribe of Chippewa Indians, is the tribe assisting with his counsel? I reviewed it at the bench with prosecution and defense counsel, and we all agreed that that would be a wholly improper question for me to ask, and so I did not do so. Right. Mr. Nightingale, you had indicated earlier that you didn't think there was going to be any defense proofs. Does that remain true?
That is still correct, Your Honor.
Okay, so Mr. Middleton, it's my practice to have a little discussion with you about your rights in that regard, because you have two constitutional rights that you can't exercise both of them because they're flip sides of the same thing. You have the absolute constitutional right to testify in your own defense at your own trial. But you also have the absolute constitutional right to choose not to and remain silent. And if you chose not to testify, the jury would be specifically instructed that you didn't have to testify, and they can't count that silence against you whatsoever. Obviously, you can't do both things. The role of your attorneys is to help you assess the strategic value of and the risks and benefits of each course of action, and to tell you how they think the trial's going and give you advice on whether you ought to testify or not. But although it's their role to give you advice, it's not their decision to make. It's your decision to make because it's your rights. Do you understand that framework as I've laid out for you?
Yes.
Have you had enough time to discuss your options with your attorney about that question?
I mean, I've pretty much heard one side of it, but I mean, I know it's not right.
Okay, I mean, do you want to talk with your attorneys a little more about whether you should testify or not?
I don't want to testify.
Okay, you don't want to testify.
Right.
And you think you've had enough opportunity to talk with your attorneys about those options?
Yeah.
Okay. All right. And so I did talk with counsel about the jury instructions in general this morning. We have, I'm intending to give well, are you still requesting the lesser included of entry without breaking with intent, Mr. Juliet?
Yes.
And Mr. Nightingale, are you still requesting the lesser of entry without owner's permission?
Yes.
Okay, so the jury instructions that I have in the final jury instruction packet includes both of those lesser included. And the only other question I had is I do have at the defense request model instruction 7.8 as to identification. It doesn't fit exactly the circumstances of the case, but identification is clearly an issue in this case, and the defense has requested the identification instruction. It'd be my intent to give it as requested. Any objection to that, Mr. Juliet, or any suggestions in that regard?
7.8.
Yeah. And I'm sorry, I don't put them in the book in numerical order because that would be so illogical. I put them in an order of some logic. It's shortly after the elements. Hit the staple, please.
I have no objection to that.
Okay, so you want me to give that instruction in the model instructions, Mr. Nightingale?
Yes.
All right. Once we go into closings and instructions then and send the jury back, what I tend to do when there's just photographs or easy documents is when the jury goes back to deliberate, be my intent to provide them 2 written copies of the final jury instructions, 1 copy of a verdict form, and then to send in with them so they don't have to send a note asking for it if they want. Exhibits 1 through 5, which is the insurance claim and some photographs, and then exhibits 8 through 25, which are all photographs. So send them back everything except the thumb drives of the videos. If they want to watch a video, they'll send us a note to do that. Any objection to my sending those, the hard copy exhibits directly in as they begin their deliberations, Mr. Juliet?
No objection.
Any objection, Mr. Nightingale?
No.
Okay. Council ready for closings, and we can go right into closings and instructions and getting delivery. All right, we're back on the record in People v. Middleton trial. Mr. Nightingale, did you have a motion?
We do, Your Honor. Thank you. So defense at this time would move for a directed verdict of acquittal under Rule 6.419A. It is defense's contention. The prosecutor now has rested and his evidence is insufficient to sustain a conviction on all 3 counts, but particularly count 1. There is no evidence before the court or the jury today that the defendant had any intent to commit the crime of larceny therein in the garage. The statute's got to be read as it's written, right? And it says larceny therein. I know that the court at our motion to quash did not buy this argument before. I think it's a different standard than it is now and today. Ms. Harmer's testimony today was a little different than it was at the preliminary examination. I believe at the prelim, she testified that the hammer was found inside of the garage, and it was not there before, and it was not theirs. Today, she testified that she couldn't really remember where the hammer was, but she thought it was outside of the garage. That would indicate that potentially these two folks never even went inside the garage. The light, it appears, comes on inside the garage, but we don't know that for sure. The camera angle is too far away to know that they're actually inside. And so as to the element of not only of breaking and entering the garage, but also the element of intent has not been shown here. Further, Ms. Harmer testified that it's her usual practice to close the garage door, but that she doesn't know if it was closed that night. We don't know if Mr. Middleton or whoever this alleged co-conspirator is, if that other guy is Mr. Middleton, actually went inside the garage. We have no idea, and we certainly can't infer from these facts that there was intent to commit the crime of larceny therein. And so under these facts, the court should dismiss count one now for lack of sufficient evidence to sustain that conviction.
Thank you, Mr. Gauthier. Mr. Juliet, your response?
Your Honor, the requirements for count one, breaking and entering a building with intent, require.
Sure. So I guess it really goes to the intent. What's the, I mean, even if there's sufficient, there's some evidence by way of the habit or routine testimony that the door would have been shut. It may not be dispositive, and I don't know whether the jury will find that to be sufficient, but I think it may be legally sufficient evidence to allow for breaking of the turning of a door handle and the opening of a door. So as I sit here, I think there's legally sufficient evidence to allow it to go to the jury that this defendant, either himself or his accomplice, turned a door handle and entered into the building. Where's the evidence of the intent to commit a larceny in the garage?
Your Honor,
there's a vehicle that they're ditching one vehicle and grabbing another. So it seems like it's a car theft case. Why is this a B&E case?
Your Honor, thieves don't commit crimes during the hours of the day. I would also note that the intent instruction permits the jury to consider what the defendant did. We don't have, that without identification, what the defendant said. We don't have that, but it also lets them consider any other facts and circumstances in evidence. There is evidence that a vehicle was stolen. There is evidence on one of the surveillance video exhibits that he was carrying a bag. There is evidence that the individuals were going through Ms. Harmer's vehicle. Nothing was taken. That's still evidence of an intent to commit a larceny. As to the building, I don't know if there has to be, I think those circumstances, the bag, the rummaging through the vehicles, and the fact that they ultimately stole the vehicle, that can still be used as evidence of intent when going into a garage at 3 o'clock in the morning.
All right, Mr. Rangel, your rebuttal to that.
Thank you, Judge. Yeah, so whatever happened outside of the garage, I don't think can infer intent inside of the garage. Nothing was taken from the garage at all. The proofs that the people did have at their prelim are different now. The hammer is now outside of the garage and not inside the garage. So did they even go in the garage at all? That's still a question, I think. But as to the intent, there is absolutely no proof here that anything was taken from inside of the garage. It's pretty clear if what Mr. Juliet is saying, that, they had this bag outside the garage, they obviously didn't get it from inside of the garage. It probably came from the silver car. So how could that indicate an intent to commit a larceny within the garage if they're carrying around their own stuff? And so that's, I think, our position at this point, that there is insufficient evidence to prove the intent element. Thank you.
All right, thank you. Well, there's defense's move for directed verdict of all 3 counts and particularly presses the point of intent on count one. In reviewing the motion, I have to view the facts in the light most favorable to the prosecution and draw every inference in their favor to determine whether the evidence, if believed by the jury, would be sufficient to allow a rational finder of fact to find that this defendant committed the crimes by proof beyond a reasonable doubt. I think a rational jury could find beyond a reasonable doubt that the defendant is one of the two suspects at the Awakened Credit Union and at the victim's property taking the truck. I find particularly compelling reviewing the bridge video and the still shots from that video with the photographs of the tattoos on defendant's hand and forearm, wrist area. They appear to be a striking match. And also in the silver car that was abandoned at the credit union, there are several indicia of Mr. Middleton's identification at that scene. His mail addressed to him, documents addressed to him, pieces of identification of financial documents or financial transaction devices with his name on it that are in that vehicle. So I think there's sufficient proof of identity. And that would mean there's certainly, I think, sufficient proof that he was one of the folks that stole this car, which would satisfy counts 2 and 3 beyond a reasonable doubt. Count 1 is honestly a closer call. I think there is some evidence that that defendant participated in an entry into that garage. There is a video showing 2 people going across the street from the credit union to the garage area. There was testimony from Ms. Harmer that it is her practice and habit to close the garage door each night. She didn't testify that she had checked it that night and knew that it was for a fact closed, but the rules of evidence do allow habit testimony to be admissible evidence. So there's some evidence that that door would have been shut. Therefore, it would have had to have been opened to enter, which would satisfy breaking. And on the surveillance video from the credit union, the garage is, there's a window that you can see that is black, showing no light inside. And then after the 2 suspects cross over to that area, the light is turned on. There's some illumination from inside the garage. And then that light goes off, and then we see 2 suspects walking around outside of the garage. We don't see the point of entry, but I think the light off, then on, then off, coinciding with the time frame of the suspects walking to and from that area, along with the habit testimony, I think would be sufficient to establish an entry and a breaking to accomplish that entry. And I am giving the lesser included offenses of the entering without breaking at the prosecutor's request. The intent element, I think, is the closest one, because it seems like the inference here is that there's some reason, it's unclear why, whether the silver vehicle was being ditched for some reason particular to the suspects, or if there was some mechanical issue that caused them to switch vehicles. But it seems that these suspects were trying to switch from the silver vehicle into another vehicle and grabbed this truck. They were rooting around in another vehicle. Maybe they were going to take that vehicle, and they decided which one they took. It seems like it's at bottom of a car theft case. But they are in the garage. And what are they doing in there? I don't know if I'm on the jury, I don't know whether I find that there is proof beyond a reasonable doubt of an intent to steal something inside the garage. However, on this, for me to take it away from the jury, I have to say that no reasonable juror or jury could find that there is proof beyond a reasonable doubt of the intent. They think, and I'm required to draw all, as I said, all inferences in favor of the prosecution. So I think given that something was stolen, that being the vehicle, given that the other vehicle was entered in and they were rooting around in there, given that it is the dead of the night, given that there is a hammer that you could infer belongs to the suspects that they're going to use either to enter somewhere or to gain access to something. I think that the intent instruction allows for a defendant's specific intent to be proven by what he did, what he said, what he did, and how he did it, and any other facts and circumstances, which includes all the circumstantial evidence. So I think all that together, in the light most favorable to the prosecution and drawing all inferences in their favor, I think there is sufficient evidence that would allow a rational jury to find proof of the intent to commit a larceny in the garage beyond a reasonable doubt. So therefore, I would deny the motion for direct verdict. I do find that the evidence supports the defense requested instruction on the misdemeanor offense of simply the illegal entry or entry without owner's permission without the intent element. There certainly would be a rational view of the evidence could certainly support that they entered it, but lacked the intent. But the motion for directed verdict is denied as to all three counts.
Thank you, Judge. I do have one more comment / I guess follow-up motion to make if
Okay. Yes.
So to sort of piggyback off of the original motion, and of course the court and the people can correct me if I'm wrong. A lot of things are said in trial and sometimes we miss things, but I don't remember ever hearing the township or the town of Wolverine is in Sheboygan County. And so I would say that this venue has not been established either. Although venue is not an essential element of a criminal offense, this is People v. Gayhart, 285 Mich Act 202, that's 216 from 2009. The determination of venue is a question of fact for the jury. The existence of venue must be proved by the prosecutor beyond a reasonable doubt. And so there are certain circumstances where that can be inferred, but I don't remember hearing specifically that Wolverine is in Sheboygan County, and nor did the court take judicial notice of the same. So I believe that venue has not been established either. Thank you.
Mr. Juliet, your response?
When I asked Ms. Tarmer where she lives, she said Wolverine, and I believe I followed up directly with Wolverine, Sheboygan County.
Well, I don't recall that. I wasn't really keyed in toward it. We were live streaming it. I guess I could pause and go back and.
It was the first witness, I think. So if it did occur.
I guess my position on that would be, I do remember and have in my notes, that the witness did testify they resided in Wolverine, and it's in the village of Wolverine, right across from the Awaken Credit Union. I mean, I think that to establish venue, the prosecution just has to establish that the crime took place in Sheboygan County. They did. They established it took place in Wolverine. And Wolverine is in fact in Sheboygan County, so there's no venue deficiency. The jury is instructed that the prosecutor has to prove that it occurred in Sheboygan County. If the jury is unpersuaded of that, maybe they'll return a verdict favorable to the defense. I don't know, but I don't know that there would be a reason for me to dismiss the charges based on that. There was clear testimony that it occurred in Wolverine. I mean, to the extent there's truly any defect there, proofs haven't closed. I mean, while the prosecutors rested their case, we haven't given it to the jury yet. I mean, we could reopen the case, or I could take judicial notice of the fact. I don't know. I mean, I think if there was a deficiency, I would certainly, as a remedy, either reopen proofs or take judicial notice that Wolverine, the village of Wolverine, is in fact in Sheboygan County. But I'm content to let the jury make that determination. And if Mr. Juliet thinks he got Sheboygan County on the record and wants to rely on that, I'll certainly let him. All right, you ready for the jury for closings, instruction, and deliberation?
Yes.
All right.
All rise.
All right, please be seated. All right, Mr. Nightingale, the people having rested, any defense proofs today?
No, Your Honor, defense arrested. Thank you.
Both parties having rested, Mr. Juliet, go ahead with the closing argument.
Thank you. Well, thank you, everyone. We certainly got done earlier than expected today, but thank you nevertheless. So again, I just want to go over the charges real quick. So we have a breaking and entering of a garage with the intent to commit a larceny of a motor vehicle, that being $1,000 to $20,000, and unlawful driving away of a motor vehicle. I want to sort of run through the timeline of what you've heard today. So there's a silver vehicle parked at the Awaken Federal Credit Union in Wolverine, Sheboygan County. There's bank video that captures two individuals going back and forth from that vehicle to the Harmer's residence. Morgan Harmer testifies that she sees two individuals going through her vehicle and rummaging through her car. Can I get the TV?
Oh, sure.
So anyway, Morgan Harmer testifies that she sees two individuals, one in a camouflage jacket, rummaging through her vehicle and ultimately steals her husband's truck. She calls 911. Police arrive and they begin their investigation. So I want to go through count one. The defendant broke into a garage. Again, breaking, that could be as simple as pushing a door open. However, in this case, there's testimony and the video that suggests there was a hammer right by the door. It's her regular practice to keep the garage door closed, and I believe she in fact testified that it was closed. So, is there a break-in? Is there an entering? Clearly, the video shows two individuals entering the garage. That's obvious because the light comes on and they both exit the garage. Biggest one is when he broke and entered the garage. What was his intent? Was his intent to commit a larceny, or was his intent to just warm up on a cold May night, if you will? Now, larceny, 1,000 or more, but less than 20,000. The defendant took somebody else's property. He took it without their consent. Some movement of the property. And at the time the property was taken, the defendant intended to permanently deprive the owner. Final element is that the fair market value was 1,000 to 20,000. Finally, count three, unlawful driving away, substantially similar elements. But the defendant took somebody else's vehicle, drove it away, knowing that he didn't have the authority. At the forefront of this trial, I told you this was going to be an entirely circumstantial case. That when you go back there, you're going to be required to connect all the dots in this case. Again, circumstantial evidence is evidence that does not directly prove a fact, but allows reasonable inferences in the evidence to allow you to come to a conclusion of fact. It requires you to draw reasonable conclusions that support a certain claim. So in this case, nobody that got on that witness stand today testified that they saw Harold Milton get in that vehicle and drive it away. Nobody saw him break and enter the garage to steal. And I'm not claiming that I know Harold Milton did it. Oh, here's what I do know. There's a silver vehicle that, by the defendant's own words, was bought by his girlfriend and he rode around in it occasionally. It's parked at the credit union across from the Harmer's residence. There is an entire wallet full of identification right by the driver's seat. Now, I don't know about any of you, but I have a hard time leaving my vehicle or my wallet in my car when I go into the store, let alone leaving it in my car when I go to steal a vehicle or steal something else. That's just not reasonable. Not only is his wallet in there, but all of his mail's in there. Mail from DHS, mail from the bank, everything's in there. Everything suggests that it was Harold Middleton in that vehicle, and not just the mail. There's a Mackinac Bridge video that shows an individual with some pretty distinct tattoos on his hand, driving through the tolls about an hour before Miss Harmer reports that she sees somebody steal her husband's truck. Deputy Pulaski takes pictures of his hands, and I've got reading glasses, don't get me wrong, and those are the same tattoos. Harold Middleton was the one driving that vehicle over the bridge. Harold Middleton was the one who parked it there, left his wallet, his social security card, his debit cards, all of that in the vehicle, and went and stole the truck, tried to get in and steal stuff from the garage. People don't commit crimes and then intend to leave evidence of their presence at the scene of the crime unless they committed it. That just doesn't happen. So, not only that, there's an individual in the bank video wearing white lettering on a black shirt. Again, I can't see perfectly, but you have a person wearing white lettering on a black shirt with a ball cap that matches the same suspect crossing the Mackinac Bridge. And then you have all these forms of ID in the vehicle that I think that only really leads to one conclusion. So now that it's beyond a reasonable doubt that Mr. Middleton, the defendant, was at the scene of the crime, the elements just flow in place. Ms. Harmer testified that she saw somebody in a camouflage jacket get into her husband's vehicle and drive it away. He obviously didn't consent to it. He testified to that. The camouflage jacket, he was wearing the white lettering. That's him. That's not the other person. He was wearing the ball cap. That's not the other person. That's him. So, count 3, unlawful driving away of a motor vehicle. There's no doubt that was him. Larceny, again, no doubt that was him. He drove it away, he stole it, it was never returned, and it was abandoned in Flint. Count 1, breaking and entering. You can see both individuals go into the garage. Now, if you do have some doubt about whether he broke in, the judge is going to instruct you on a lesser included offense of entering without breaking with intent. So if you don't find that he broke in or pushed the door open, which I think is, I think it's pretty clear the door was closed. There's a hammer right there. That wasn't the Harmers. They wouldn't be taking a hammer if they didn't need it to a door. So I think they broke in. But anyway, you can still find the defendant guilty of entering into that garage with the intent to steal, and that's entering without breaking with intent. Ladies and gentlemen, again, I'm very cognizant that this is not a direct evidence case. I've known that from the start. But direct evidence isn't required. The law doesn't require it. It requires you to connect the dots. So now when we put all of these things together, the hand tattoo, we can confirm it. the vehicle, all of his ID in there, the mail, the ID, the bridge video, the hand tattoo, and the bank surveillance that shows him coming back from the house in white lettering and a ball cap. Harold Middleton was at that house. He drove that vehicle there. He committed those crimes. I'm going to ask you to find him guilty of all 3 counts. Thank you.
Mr. Juliet, Mr. Tiggio.
Thank you. I'm okay to try to move this a little bit.
Yeah.
It's been bothering me all day. Okay. Good afternoon, everybody. Thank you so much for being here and for obviously paying such close attention. We really appreciate all the questions that you guys asked, and it shows that you're actually paying attention. So both of us appreciate that here. You guys are going to have this really awesome responsibility, and what we want you to really consider as far as this case is concerned are what are the coincidences? What's the circumstantial evidence? And use your common sense to apply the two together, right? So we talked a lot in Gauthier about, have you ever left something behind that's really important to you that you really can't live without, right? We talked a lot about phones. Some people did mention some wallets, but, the overarching theme here is, right, that even if something is really necessary for you to live your life, you may leave it behind and maybe not notice for several days before someone else points out to you that you left something in a car or in a restaurant or wherever, right? I mean, people are human, they make mistakes. When Debbie Gauthier goes and talks to Mr. Middleton, Mr. Middleton says, yeah, I mean, that's my girlfriend's car. Yeah, sure, my wallet's in there. It's her car. This is almost a year after this incident is alleged to have occurred. And so I hope that all of you don't hold against Mr. Middleton that he did not remember being in Sheboygan County or driving over the bridge or doing anything a year earlier. I mean, if we use our common sense and we think back, some of you filled out your juror questionnaires around April, May, June of 2024. Think about where you were when you filled it out. Do you remember filling it out? Do you remember what you were thinking about when you filled it out? Do you remember, all the things that happened in life? Can you remember each and every fact about that day, right? I would say that probably none of you can because it was too far back in time for you to really have a vivid memory unless something substantial occurred to you to make you remember it, right? And so I hope that you guys aren't going to hold that against him because there's just, in my imagination and using your common sense, no way that he could have just known, I was there or I was not, right? All he knows is the car was his girlfriend's and his wallet was inside of it, period. Now, when we get to the elements of the offenses here, right? We're talking about count 1, breaking and entering a building with intent. The juror instructions are pretty clear on that. You have to find that he had an intent to commit a larceny inside of the garage once he entered the garage. This is not about what did or did not happen outside of the garage as to count 1. Count 1 is about the garage itself. And so what you heard from Ms. Farmer when she testified was that she generally closes the garage. She said that she thinks that she closed the door that night, but that she's not sure. She thinks that there was a hammer left outside of the garage. There is no indication from her testimony that anyone went inside of the garage. There's no testimony from her that the door was broken into, as Mr. Juliet may allude with the hammer. If that happened, you better believe that she would have remembered that and volunteered it today. But no, there's no actual evidence that anyone, let alone Mr. Middleton, broke into the garage with an intent to steal something from the garage. right? And so count one is just dead on arrival, or at least should be in your minds when you use your common sense. Now, let's talk about count two, okay? Committing the offense of larceny by stealing a 2010 Ford F-150 that belonged to Lance Harmer. There's, I don't think, any dispute of the value of the vehicle, although it's a pretty old truck. Still is probably worth at least $1,000, right? And you have the insurance statement says they got paid out about $9,000 for it. So no dispute there. I think really the dispute as to count two and count three is who done it. What the prosecutors presented to you today should not be sufficient in your minds to find Mr. Middleton guilty beyond a reasonable doubt. Here's what, and you're going to get a bunch of instructions again from the judge, so I don't want to belabor the point, but I do want you to pay some specific attention to some of these instructions. The first one is about the presumption of innocence, the burden of proof, and proof beyond a reasonable doubt, okay? It gives you this definition that says proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence, right? I don't know who you guys hang out with in your free time, but there are plenty of folks in the state of Michigan that have hand tattoos. Mr. Middleton is not the only one. And so the fact that somebody has a similar hand tattoo is not proof beyond a reasonable doubt. It's still just circumstantial evidence. And when you get to the instruction on circumstantial evidence, which is 4.3, it's going to talk to you about, what that means, right? And give you some guidance on how to apply that. That circumstantial evidence can be enough to convict a person beyond a reasonable doubt, but you got to be really sure that it is proof beyond a reasonable doubt. You may consider circumstantial evidence. That can be by itself or a combination of circumstantial and direct evidence. I think it's not in dispute at all. There is absolutely no direct evidence that Mr. Middleton did anything May 6th of 2024. The only thing that the prosecutor can show you is this moving video across the bridge where it looks like somebody's got a hand tattoo. Sure. He can show you the wallet inside of the car, which obviously Mr. Middleton has explained through his statement to police. Further, this T-shirt with the white lettering. I don't know where to start there. I wish that one of you would have been wearing a T-shirt with white lettering today, because I would have pointed at you and said, you must have done it. That can't be enough. A white male in the state of Michigan wearing a T-shirt with white letters on it. I think you probably throw a rock and hit one. Maybe not in this room right now, but just generally, they're out there, right? And so that is also not enough to show by a reasonable doubt, beyond reasonable doubt, that Mr. Middleton committed these offenses. When we go back to Ms. Harmer's testimony, she's awoken by her kid. It's like 4 o'clock in the morning. She goes over to the window and she sees these two guys outside. One of them she describes in camo with this hat. She describes that gentleman actually with long shaggy hair. And I mean, I know all of you have eyes right now. Certainly Harold does not have long shaggy hair, and I don't think you heard any testimony that he at any point had long shaggy hair. And so that seems to fly in the face of any sort of identification of Mr. Middleton as the person who was wearing that camo jacket and who obviously committed these crimes. There's no attempt really to find the second person. But the people's contention is that they think that Mr. Middleton was in the camo jacket. Nonsense, right? Because as the person in the video of the car crosses the bridge, you see the hand tattoo, you see the T-shirt with the lettering, but you don't see the camo jacket, you don't see the hat, you don't see the long shaggy hair. You don't even see a second person in the car. Where's the second person? Does he just like magically fall out of the air? These are all questions that you guys should still be having. And any questions that you have that are lingering need to be resolved against the prosecutor, because it is his burden to show each and every one of you proof beyond a reasonable doubt of every single element, right? And so if you have any questions at all, then Mr. Middleton is not guilty. When you go back to the jury room and you deliberate, I think all of you are going to have additional questions. All of you are going to see that there are missing pieces to this puzzle. And when the prosecutor told you in his opening statement that there is only one way that this puzzle fits together, that's just not accurate. I know that he wants to fit them together in a certain way. He wants to show that Mr. Middleton is guilty, but he just cannot do that based on this evidence. You know, when I talked to the sheriff's deputies earlier on the stand, you know, Deputy Koloski particularly, we talked about actually finding this truck. The truck was found in Genesee County. You know, it seems like the guys down in Flint are just too busy to solve crimes, apparently. But, you know, someone from up here could have gone down there and gotten that car and ran fingerprints on it. And at the end of the day, had they chosen to do that, we might actually know who committed this crime. The harmers might actually get justice. But they decided not to do that for whatever reason. You know, the sheriff's office makes this decision on the scene, even with this silver car. With one of the vehicles, I think the car that's still left in the harmer's driveway, they make a decision on scene, well, it's just too dewy, and so we can't do it. And there was not even an effort to try. It's just very unfortunate for all of us, because had that effort been made, we might actually know who did it. And now we don't. The sheriff's department waits a year before they go and talk to Mr. Middleton. If what these deputies are saying today is correct, they knew probably within 48 hours that they had a suspect that they could go talk to, and additional witnesses who may be able to identify the person that was actually in the vehicle. They wait a year before they go talk to him. They make a few phone calls to another person. Those phone calls are obviously not successful. Don't even bother to talk to anybody else who's listed in the vehicle, including another male. Who's the other male? We don't know. You don't know. Nobody bothered to talk to him. Does that guy have hand tattoos? I don't know. And you don't know. You know, there's really no actual evidence here that Mr. Middleton did anything. And the facts as presented to you all are just not convincing. At least they shouldn't be convincing to you. You know, this proof beyond a reasonable doubt, it's a strict and it's a heavy burden. And it's just so important that you guys take it seriously. And I think that you are going to. But, you know, at the end of the day, Miss Harmer has no idea when that silver car actually was parked there. She went to bed, she thinks probably around 10 or 11. I didn't hear specifically from her that she regularly looks out into the credit union parking lot to verify the amount of cars that are still parked there. I didn't hear from her that, in fact, she did look out that night and didn't see the car. She didn't notice that it was there before she went to bed. Those are different statements, and I hope that you guys can see that and that you heard that. You know, obviously, Mr. Harmer didn't give permission for anybody to take his truck. That's really not in dispute, right? I don't think that he walked out the door and said, "Please take my truck." He didn't do that. We're not disputing that, but who actually took it, who was actually there, is certainly in dispute. And what I think that you guys should do when you go back and you look at the evidence again, look at the timestamps again, because on the bridge video, because the timestamps are different. They have a 3:03 a.m. timestamp up in the left corner, but there's a clock in front of the toll booth worker that's showing a different time. Granted, it's not a different time by a lot of minutes, right? But that's something that you guys should consider when we're putting this timeline together. It needs to be perfect from the prosecutor's perspective. It needs to be perfect. And if it does not line up for any of you for any reason, then it is a not guilty on all counts. And so what we're asking you all to do, again, is look at the evidence. What did you hear? What did you not hear? What did you see? What did you not see? When you're going through the Awaken Credit Union video again, I mean, you can see the guy's hands in the camo jacket at a certain point. Do you see any hand tattoos? I mean, look at it, you tell me. And so for all of those reasons, we're gonna be confident that you guys, upon reviewing the evidence and deliberating, are gonna find Mr. Middleton not guilty on all counts. Thank you.
Thank you, Mr. Langdon. Mr. Juliet, any rebuttal argument?
Thank you. Well, I want to start with one thing that or two things rather, that I agree with Mr. Nightingale. I agree that you should all, when you go back there, do nothing but use your common sense. His suggestion that somehow he left his ID in that vehicle by an accident doesn't make sense. Those two individuals in that credit union surveillance, they were not females. It wasn't his girlfriend. That's nonsense. I want to touch on the intent to steal in the garage again. What normal person goes through and starts rummaging through somebody's vehicle, or two people's vehicles rather than that, then steals a truck, but goes in the garage in the interim to, I don't know. Who does that? I guess that's up to you. I know it's not a normal thing to do, especially given the circumstances when a vehicle was stolen. The other thing I agree with is this case really is about who done it. And with that, I will leave you with exhibits 1 through 25. And you guys are all reasonable people. I have no doubt you'll find out who done it. There's this notion that law enforcement didn't do their job that night. They didn't get fingerprints. Happens every day. And I'm not a scientist, but if there's dew on a vehicle, you're probably not getting fingerprints. It's just not going to work. Flint police, apparently they're on trial today too. I don't know. It would be a interesting use of resources for the sheriff's department to go down to Flint to try and fingerprint a vehicle that's abandoned in an abandoned lot that's no longer usable. And there's no chain of custody. I mean, Mr. Middleton could have dropped that vehicle off in Gaylord. Somebody else takes it to Flint. I don't know. What I care about is who's at the scene of the Harmer's residence committing the crime. That's what you should care about. And that's what we're here for. They didn't interview the other guy. Well, there's a pretty reasonable explanation for that too. They didn't interview the other guy because his wallet with his social security card, his debit cards, his mail wasn't left in the vehicle. How do they know who it is? The defendants
life was in that vehicle, basically. You see him crossing the bridge, you see the tattoos, you see the white lettering, you see all the evidence. I'm gonna leave it to you. I know you're reasonable people. Thank you.
All right, well, members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I'll explain the law that applies to this case. Now, the instructions that I'm reading you now, I will send you back into the jury room with a couple copies of for your review, but I won't give each of you a book like the beginning of this. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision, and you must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about the case individually, but you should do so only after listening to and considering the opinions of your fellow jurors who may have different backgrounds or perspectives from you. As jurors, you must decide what the facts of the case are. This is your job and nobody else's. You must think about all the evidence and decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You shouldn't pay attention to some and ignore others. To sum up, it's your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. I remind you again that a person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent, and this presumption continues throughout the trial, and it entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements, and the prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant's not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair and honest doubt growing out of the evidence or the lack of evidence. It's not merely an imaginary or possible doubt, but it's a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that's reasonable after a careful and considered examination of the facts and circumstances of the case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything I tell you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such, and I'll describe some of those things for you. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he's charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept the things the lawyers say that are supported by the evidence and by your own common sense and general knowledge. The lawyer's questions to witnesses and your questions to witnesses or any of my questions are also not evidence. You should consider these questions only as they give meaning to the witness's answers. My comments, rulings, questions, and instructions are not evidence. It's my duty to see that the trial is conducted according to the law and to tell you the law that applies to the case. However, when I make a comment or give an instruction or make a ruling, I am not trying to influence your vote or express any personal opinion about the case. If you believe that I do have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence I let in and nothing else. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, You must decide this case based only on the evidence admitted during the trial. Facts can be proven by direct evidence from a witness or exhibit, and direct evidence is evidence about what we actually see or hear. For example, if you look outside and see it raining, that's direct evidence that it's raining. Facts can also be proven by indirect evidence, which we call circumstantial evidence. And circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you saw a person come from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it was raining. You may consider circumstantial evidence. Circumstantial evidence by itself or in combination with direct evidence can be used to prove the elements of a crime. In other words, you should consider all of the evidence you believe. As I said before, it's your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You don't have to accept or reject everything the witness said. You're free to believe all, none, or part of anyone's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's disability, race, national origin or ethnicity, gender, gender identity or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. First, was the witness able to see or hear clearly? How long were they watching or listening? Was anything else going on that might have distracted them? Do they seem to have a good memory? How did the witness look and act while testifying? Did they seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge their testimony? Do they have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, do they have any special reason to lie or special reason to tell the truth? All in all, how reasonable does their testimony seem when you think about all the other evidence in the case? Now, sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, or whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they saw or remember. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied to you about something important to how you decide the case. If so, you may choose not to accept anything the witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You've heard testimony from witnesses who are police officers. Their testimony is judged by the same standards that you would use to evaluate the testimony of any other witness. In count one, the defendant is charged with the crime of breaking and entering. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant broke into a building. It doesn't matter whether anything was actually broken. However, some force must have been used. Opening a door, raising a window, or taking off a screen are all examples of enough force to count as a break-in. Entering a building through an already open door or window without using any force does not count as a break-in. Second, that the defendant entered the building. It doesn't matter whether he got his entire body inside. If the defendant put any part of his body into the building after the breaking, that's enough to count as an entry. Third, that when the defendant broke and entered the building, he intended to commit the crime of larceny, which is an unlawful taking or carrying away of another person's property without their consent with the intent to permanently deprive the owner of the property. On count one, you may also consider the lesser charge of entering without breaking. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant entered a building without breaking. It doesn't matter whether he got his entire body inside. If the defendant put any part of his body into the building, that's enough to count as an entry. Second, that when the defendant entered the building, he intended to commit the crime of larceny, which is an unlawful taking or carrying away of another person's property without their consent, with the intent to permanently deprive the owner of the property. Still, as to count one, you may also consider the lesser charge of entering a building without the owner's permission. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant entered a building. It does not matter whether the defendant got his entire body inside. If the defendant put any part of his body into the building, that's enough to count as an entry. Second, that the defendant did this without first getting permission to enter from someone who had authority to give permission. In count two, the defendant is charged with the crime of larceny. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant took someone else's property. Second, that that the property was taken without consent. Third, that there was some movement of the property. It doesn't matter whether the defendant actually kept the property or whether the property was taken off the premises. Fourth, that at the time the property was taken, the defendant intended to permanently deprive the owner of the property. The intent to permanently deprive includes the retention of property without the purpose to return it within a reasonable time, and includes withholding property or causing it to be withheld from a person permanently or for such a period of time that the person loses a significant part of its value, use, or benefit. Fifth, that the property had a fair market value at the time it was taken of $1,000 or more, but less than $20,000. In count three, the defendant is charged with the crime of unlawfully driving away a motor vehicle. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the vehicle belonged to someone else. Second, that the defendant took possession of the vehicle and drove it away. Third, that these acts were both done without authority or without the owner's permission. Fourth, that the defendant intended to take the vehicle without authority, knowing that he did not have the authority to take the vehicle and drive it away. It doesn't matter whether he intended to keep the vehicle. And anyone who assists in taking possession of a vehicle or assists in driving or taking away a vehicle, knowing that it was unlawfully possessed, is also guilty of this crime if the assistance was given with the intention of helping another commit this crime. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about May 6th, 2024, within Sheboygan County. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts or circumstances in the case. One of the issues in this case is the identification of the defendant as the person who committed this crime. The prosecutor must prove beyond a reasonable doubt that the crime was committed and that the defendant was the person who committed it. In deciding how dependable an identification is, think about such things as how good a chance the witness had to see the offender at the time, how long the witness was watching, whether the witness had seen or known the offender before, how far away the witness was, whether the area was well lighted, and the witness's state of mind at the time. Also think about the circumstances at the time of the identification, such as how much time had passed since the crime, how sure the witness was about the identification, and the witness's state of mind during the identification. You should examine the witness's identification testimony carefully. You may consider whether other evidence supports the identification, because then it may be more reliable. However, you may use identification testimony alone to convict a defendant, as long as you believe the testimony and you find it proves beyond a reasonable doubt that the defendant was the person who committed the crime. Any possible penalty should not influence your decision. If you find the defendant guilty, it would be the duty of the judge to fix the penalty within the limits provided by law. So when you go to the jury room, you'll be given 2 copies of these final jury instructions. You should first choose a foreperson. The foreperson should see to it that your deliberations are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn your cell phones or other communications equipment off entirely until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you'll discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. Therefore, it's your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for those opinions, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and don't hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you, or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. I've already given you instructions regarding lesser offenses. As to any count which includes a lesser offense, you must first consider the principal offense. If you all agree that the defendant is guilty of that offense, you need not consider the lesser offenses as to that count. If you believe that the defendant is not guilty of the principal offense, or if you can't agree on that offense, then you may consider the lesser offenses. It's up to you to decide how long to consider the principal offense before discussing the lesser offenses. You may go back to consider the principal offense again after discussing the lesser offenses if you want to. If you have any questions about the jury instructions before you begin your deliberations or during deliberations, you may submit them in writing to the bailiff. In fact, if you want to communicate with me at all while you're in the jury room, please have your foreperson write a note and knock on the door. The bailiff will be just on the other side of the door waiting for your knock. And then hand the note to the bailiff. It's not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, don't reveal this to anyone outside the jury room. And when you go to the jury room to deliberate, you may take your notes, and I'll send you in with 2 copies of my final instructions. I'm also going to send you in with the documentary and photographic exhibits, so that you don't have to ask for those. If you want to view any of the videos, you have to send out a note for us to facilitate that. You'll be given a written copy of these instructions you've just heard. As you discuss the case, you should think about all my instructions together as the law that you are to follow. So the defendant again is charged with 3 counts. That is with the crimes of breaking and entering, number 1, larceny, number 2, and unlawful driving away an automobile, number 3. These are separate crimes, and the prosecutor is charging that the defendant committed all of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of all or any combination of these crimes, guilty of a less serious crime, or not guilty. And I've prepared a verdict form for you to consider. And the verdict form is 2 pages stapled together. It has the case caption, and it says you may return only 1 verdict on each count. Mark only 1 box for each count. There will be count 1, breaking and entering. There's a box for not guilty. There's a box for guilty of breaking and entering. And then there are separate boxes below that of the lesser offenses that I have instructed you. And then I've got this similarly for counts 2 and 3, a box for not guilty, and then a box for guilty of that charge. So what you will do is when you're in the jury room, when you reach a verdict, you want to have your foreperson make sure that the verdict is marked appropriately, and the foreperson will sign and date the verdict form and fold it once. Knock on the door. When the bailiff answers, tell the bailiff that you have reached a verdict, but don't tell the bailiff what that verdict was, and do not hand the verdict form to the bailiff. We will bring you back into the courtroom. The foreperson should come out holding the verdict form folded once in their hand. And then I'll give you specific instructions on the manner in which we'll receive your verdict in open court. All right, and at this time we did have, we selected 2 alternates because I really did think we'd go into a second day. So we will at this point select two of our jurors by random selection that will be excused as alternates. If you are chosen as an alternate, sometimes people are disappointed that they don't get to deliberate in a case they heard. Other times people are relieved that they don't have to deliberate in a case they heard, whatever the case may be, I want to assure you that your presence was important to present the constitutional right to a jury trial. Many times we do have to rely upon the presence of the alternates to go forward. So if you are selected as an alternate, you'll be excused and they're free to talk about the case with anybody that you wish, except of course the other jurors who remain on the case. And you're free to stick around in the gallery and watch what happens or go home at your choosing. So at this time, we'll ask the clerk to randomly draw two of our jurors.
Juror 339, Angela Small.
Okay, and that's in seat 9. Ms. Small, thank you very much for your service here today. Be excused. Do you have anything in the jury room?
I do. I have.
Okay,
all my
what'll
stuff
happen
in
is the bailiff will escort the alternate jurors into the jury room just so you can retrieve your items,
there. That way.
and then he'll direct you as to how to go.
Okay.
Our
Thank
second, okay, thank you. Our second alternate.
Juror 289, Amber Burton.
Okay, and that's in seat 10. Thank you again for your service, and the bailiff can escort you into the jury room or. We need the bailiff back for the next thing, so we'll wait for him. Thank you. And at this point, we'll have the clerk administer an oath to the bailiff.
You do solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors in this trial from separating from each other, that you will not suffer any communication to be made to them orally or otherwise, that you will not communicate with them upon order of this court, and that you will not, before they render their verdict, communicate to any person the state of their deliberation or the verdict they have agreed upon. So help you God.
All right, so at this point, members of the jury, I'm going to have the bailiff escort you back to the jury room with 2 copies of the instructions, the exhibits I mentioned, and 1 copy of the verdict form.
All rise.
Please be seated. All right, Mr. Juliet, are the people satisfied with the instructions as given?
Yes, Your Honor.
Mr. Nightingale for the defense?
Yes, Your Honor.
Any other issues that you want to place on the record, Mr. Juliet?
Just more of a question, just as far as the video exhibits, they're going to come. Should I just leave mine in here ready to go, or?
Yeah, why don't you leave your laptop present in case they send something out that they want to watch it. We'll probably just have you play it in the manner that you did. Rather, we don't have a way, and I don't want to build a way for me to send media back in to a deliberating jury. We'd have them come out and we'd play it on here without any commentary or questions.
Very good.
Anything else to put on the record from the defense?
Judge, I would just request that if Mr. Juliet's going to be present for that I also just be present.
Oh, absolutely.
Just from a perception thing, not that.
I would never, there have been some case law in this. I would never have the jury out here that we would engage with without both counsel present. Yes, absolutely. So in that regard, it is my practice to make sure we don't keep a deliberating jury waiting. So I instruct counsel to make sure we have a cell phone number to reach you immediately, and also that you not leave the courthouse grounds, so that if the jury has a question, we can get you back in here within moments and we don't leave them waiting. So you're not to leave the courthouse then. All right, so we'll be in recess until we receive anything from the jury. And thank you both for case was well tried on both sides. Thank you.
All rise.
They're requesting, it says all videos, and then that is stricken twice. And then underneath it says bank video in the singular. So I'm open to suggestions from council. I would note that we have actually 4 bank videos, one being exhibit 7, which is the 1 hour, which was not published or played to the jury. And then we have exhibits 7A, B, and C of varying much shorter lengths. I guess I would propose, although it's not the most efficient process to have them come in and out and in and out, but I don't like to engage in discussions with the deliberating jury on the record. For your consideration, what I might propose is we bring the jury out, I acknowledge the question, and I tell them that the process would be that we would play the video for them in the courtroom with everybody here without any commentary, questions, or discussion. We don't have a method for them to view it on their own direction in the jury room. And therefore, we would need them to specifically send us a note as to which bank video they mean, exhibit 7 or exhibit 7A, 7B, or 7C. Do you want me to, and if I do that, do you want me to remind them that exhibit 7 is an hour long?
That's fine with me.
Any objection to that? I mean, maybe they want to watch the whole hour, and that would be fine if they do.
And they may, I have a feeling they probably just want to watch the snippets again, if I had to guess, but.
Yeah, that'd be my guess, but I don't want to foreclose that. Any objection to that or any other ideas or input, Mr. Julian?
No, I don't have any other ideas.
Likewise.
Judge, does it make any sense to send back to tell them what A, B, and C are?
I don't know what they are. They're just they're snippets. I don't want to get into describing what we saw on it.
Okay.
I think that would be me commenting on the evidence.
Okay.
I will tell them that exhibit 7 is the 1 hour complete. It's not complete, but the 1 hour video that was not played for you. 7A, B, and C are shorter segments that were each played for you. If you can send us a note as to which or which of those or which combination of them that you want played.
Yeah, okay.
Does that sound fine?
Yes.
Okay, let's have a jury.
All rise.
All right, so please be seated. All right, members of the jury, we did receive a note that says we are requesting bank video. I want to just describe for you the process here for that. We don't have a way for us to send you the thumb drives for you to just play on something in the jury room at your direction back and forth. The process for that would be, we'll play the video on the screen as you saw before, all in the courtroom as we are now. However, there would be no commentary by anybody, jury or lawyers, no questions. We would just play it silently and send you back. But because of that, we need to know, don't tell me now, we need to know which video you mean. We actually have 4 exhibits. One is exhibit 7. That's the full hour-long video that you were not played. Then we have 3 shorter snippets that you were played, 7A, 7B, and 7C. So we would need a second note from you about which, if any, or any combination of those that you would want to watch together here on the large screen. So I'm going to have to send you back into the jury room and have you discuss as a jury how you want to proceed with that. And if you do want to come in and watch anything, just send us a note to that effect.
All right.
All right, please be seated. Mr. Juliet, any objection?
No.
Mr. Tiggio?
No.
All right, we'll stand again in recess. Go off the record. We're back on the record, and we did receive another note from the jury, and it says requesting 7A, 7B, 7C bank video. So I would propose that if Mr. Juliet wants to get it keyed up, we can have the jury in and seat them, and then just simply without, and I'll say we received this note, we're going to play you all 3, one right after another, without any comments or questions from jurors or attorneys. Does that sound fine, Mr. Juliet?
Yes.
Mr. Tiggio?
Yes, sir. Thank you.
So let me get this all ready to go. So.
There's your suspect. Right there.
Your backdrop's on YouTube right now if you want to get the video up and ready to play.
Slides. PowerPoint.
I always had treats in my pocket that so like sticks and those in your pocket.
Okay. All right, so you're ready to play that when we tell you that, and then you can just, when that's done, just open up B without my direction and C without my direction, just play them all through. Okay, ready for the jury then?
All right.
We did receive a second note from the jury. It says requesting 7A, 7B, 7C bank videos. So what we're going to do is we're going to play it for you again on this large screen, A, then B, then C, without any commentary or questions from me or the lawyers or from any of the jurors. Once we're done with all 3 of those, we'll just simply send you back into the jury room to continue. All right, so we're going to send you back to your jury room to continue your deliberations.
All right.
Or any objections or anything you want to place on the record about that, Mr. Julia?
No, thank you.
Mr. Nightingale?
No.
Okay, we'll be in recess. All right, please be seated. All right, so members of the jury, have you selected a 4-person to speak for you?
Yes.
Okay, and without telling me what it is, have you reached a verdict?
Yes.
Would you please hand the verdict form to the bailiff? And 4-person, would you please stand and announce your verdict into the record, please, as to each count?
Okay, count 1, breaking and entering, not guilty. Count 2 of larceny, not guilty. And count 3 of unlawful driving away with an automobile, not guilty.
Okay, thank you. Would you please hand the verdict form back to the bailiff? Mr. Juliet, would you like the jury poll?
No, thank you.
Okay, members of the jury, thank you for your service here today. And this discharges you from your service, and you're free to talk about the case with anybody you wish. I am going to ask that the bailiff will show you back into the jury room. And if you can just wait there just a moment or two, I'll be back just in a moment just to speak with you.
All rise.
All right, please be seated. All right, the jury having returned a verdict of not guilty on all counts, the court will prepare a judgment of acquittal. Is this the only matter that Mr. Middleton is in custody on?
Currently, this is the only thing that's holding him. He does have a probation sentence out of Chippewa County that upon release, he would need to go report up there.
Is there a hold?
To my knowledge, no. He served his executed sentence on
So
that
he just
portion.
he has to report to his probation officer up there?
Correct.
So we'll make sure, we'll stick around and we'll get the order of acquittal entered tonight so you can be discharged tonight. Okay, thank you both very much.
Thank you, Judge.